Welcome to our live studio audience here at Stanford University. I'm supposed to get you to cheer. Great. This is Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman. Hi, Joe.
Hi, Pam. Talking about a live show, there's really no livelier guest we could get than Dahlia Lithwick. Dahlia has been the senior editor at Slate for almost 20 years. She writes a Supreme Court and jurisprudence column. She does a terrific bi-weekly podcast on the Supreme Court. Dahlia, I have these pages in front of me because they're filled with your achievements, of the kind of awards you've won. I'll just mention a few. Elected to the Academy of Arts and Sciences, first online journalist to win a National Magazine Award. You're working on a book, Lady Justice. A little too early for people to reserve it on Amazon, though. But welcome to Stanford Legal, and it's great, you know, when you're a faculty member and a former student does such magnificent work, it gives everybody a great feeling. So I think everybody here is avid readers, and I bet everyone in our audience is.
Well, thank you. Thank you. I'm supposed to tell you to clap. Thank you to Joe and to Pam and to Stanford for inviting me back, and all of you alumni weekenders. And you know, one fears a little bit that one is going to come back to an event like this and the locks will have been changed and they'll be like, oh, this isn't Stanford anymore. That's, you know, we moved it so that you would not come into the building. So it's lovely to be back, and I believe I took evidence in this very classroom, but I am really like covered in goosebumps and sweat just from being back right in this room. But thank you nevertheless for not changing the locks.
Well, it's great to have you back. There have been changes at the law school, and I think many of you who've come back have noticed what a great building it is. I was having breakfast with an alum this morning who said that the building looks like if the Four Seasons Maui had a law school, this would be it. It's fantastic to have you here, and it's fantastic to have Dahlia. I read everything you write religiously because I love it, and I wanted to start off by talking a little bit about how you cover the court. And I want to start with a brief passage from one of Dahlia's columns earlier this year. It was a column where she was writing about a vote purge case, and what could be more apropos right now than talking about vote purging. But what she said there was, she was kind of referring back to a gerrymandering case earlier in the term, and she said, you know, one of the things that happened there was the Chief Justice criticized the lawyers for trying to come up with a formula for dealing with political gerrymandering that he called sociological gobbledygook. And then she said the mild-mannered sociologists went wild, and it was widely agreed that dismissing other fields of inquiry as gobbledygook is not generally good for lawyers. And then she went on to describe the case in front of the court, and she said, Wednesday morning at oral argument in the other monster voting rights case of 2018, this actual statement was offered by a lawyer. It's a rule, and now this is the statement from the transcript. It's a rule of clarification. So it says you have to construe B2, and I think with that, combined with the solely clause, make quite clear you have to interpret by reason of language in some other way to break the causal link between voting and removal that is required in D. And then she said, so yes, lawyers should eschew accusing other professionals of gobbledygook. One of the things that is so wonderful about your writing is the way in which you explain very complicated cases in language that's not only precise enough for the lawyers to think you're getting the content right, but readable enough for other people. And I just wonder how you go about doing that.
So I think it's partly a function of, for a very long time when I started covering the court, and I really started covering the court, you know, I finished law school, I clerked, I worked at a divorce firm for a couple of years. I suddenly was parked in the court and I had no idea what was going on in there. And I was the first online journalist in there. Years later, one of the press officers said, oh, we used to call you the barbarian at the gate behind your back, because I just sort of stumbled in and I didn't know things. And I think I quickly just realized that I could pretend to know things, or I could just be okay being the science reporter who explains to people who don't know things that, I'm kind of trying to figure this out too. And I think that I was coming in at a time where, much more so 20 years ago than now, the press corps was very, very self-mystifying. It was like, the U.S. Supreme Court press corps thought of themselves as sort of baby con law professors. And they really wanted to be, sort of imbued with the gravitas that, the Larry Tribes and the Kathleen Sullivans imbued on their own, like this is what matters, doctrine. And I came into the court and I was just like, well, I'm not a con law professor. I'm not even a baby con law professor. But what I can do is try to imagine my dad, who's an econ professor and doesn't understand, what Article 4 means, but Article 3 means, or any of the articles, or really the Constitution, if I can just put myself in his shoes.
That's not because you're Canadian.
Well, it is. That's exactly why. I mean, the articles mean nothing to him, and including my articles. But I think that I just made myself really comfortable with not being kind of all-knowing. And as a consequence, if something struck me as like, this is hard, or this is tricky, or, I don't know the law of the sea, and I can't teach it to myself in an hour, I will just be the person who asks the questions and says, I'm going to be a little bit humble about my knowledge.
So sometimes one of the things I love about your columns is the way that you focus on the dynamic of the argument in the courtroom, and in the course of doing that, you sort of slip in some really important and substantive points. And it's kind of like when you put your dog's pill inside of a piece of liver. It's in there. And my favorite column of all of your columns, and there are so many great ones, it's hard to come up with a favorite, but my favorite one was, Dahlia wrote a column about the oral argument in a case called FCC against AT&T that involved an exemption under the Freedom of Information Act that said that certain kinds of personal information would not be turned over. And she wrote the entire column from the perspective as if AT&T were a person. It was called Reach Out and Touch Someone. and the column ended this way. She said, AT&T seems to understand that somewhere along the line, he has lost the confidence of the Chief Justice. Maybe he isn't a real person capable of dignity and shame and other strong emotions after all. Maybe if you prick him, he does not bleed. If you tickle him, he does not laugh. If you poison him, well, AT&T rises to leave the room, but he suddenly finds that he has no legs to stand on. And what I loved about this column is it is screamingly funny. You should all go back and read it. But at the same time, it makes a really important point about how the Supreme Court has begun to treat corporate personhood. That in a variety of contexts it's done this. And so that's one of the reasons it's my favorite column, is because I laugh, I cry, it was better than cats, and at the end I'm thinking about something. What was your favorite column? Or is this like your son's?
I totally have a favorite son. Joking. I don't have a favorite. I mean, there was one column I remember doing where I imagined if each justice was a dog, what kind of dog they would be. I think what I always just felt was that I could either go in and do, it straight for the, for the law wonks, or I could go in and do it for my next door neighbor and the moms at the bus stop, who tended to say overwhelmingly, like, I just don't read you because I don't understand. And so I think, the ones like that where I tried to make some larger point and also say, the Hobby Lobby case is coming. The court's going to take seriously the argument that the Green family, as a family, somehow imbues their corporation with religion. I wanted to make that point, and I think, often when I do it, I feel like underlying the question is, humor is a really good, like, if you're gonna put the pill in the liver, let the liver be comedy, because I think humor is a really good disarming way in, and I think that people, A, want to be amused, and B, I think they will having something reframed is always good. And also, I think Freud, was quick to say humor is kind of a shock. And I think that if you can try to say, I'm going to take, Pax law professors, like one of the most boring institutions, and try to shock you into thinking about it in a different way, then more people might feel like they have some skin in this game. And so I think that was the animating, both there and in some of, the dog columns and some of the crazy. I've definitely gotten a little grumpy in my old age. There's much less jazz hands than there was at that period. But I do think that like shocking people into, hey, I get the principle and I could come to care about this, even if I'm not a lawyer, was always the animating value.
This is Stanford Legal, and today we're talking with Dahlia Lithwick about the Supreme Court. Joe?
I wanted to bring up a kind of a Debbie Downer subject here, but it's a much different way of getting someone's attention, and it was a column you wrote last year that I found gave such a nuanced portrait of what it's like live in a little bit of an abusive relationship. And the name of the column, for those listeners or people in our audience that want to look at it, is something like Judge Alex Kozinski made us all victims and accomplices. And it starts with this stunning story, a personal story, of you calling up somebody in his chambers. You're a law clerk, you're working for a judge somewhere, and you have a friend there. The judge picks up the phone, asks you like who you are, finds you in a hotel room and asks, what are you wearing? And the story proceeds with boundary crossing after boundary crossing over the years. And I wonder if you'd be willing to just share one of those with our listeners instead of me describing it.
I mean, I was, that story was later construed as me tooing Judge Kozinski. And I did, in that piece, disclose secrets that I had kept for 2 decades. But to me, I thought that the reason I wrote that piece, and I think my regret about that piece is when it got picked up on Twitter, it was Dahlia Lithwick me too'd Alex Kozinski, and that was never the point. The point for me was, your initial point, which was this was a piece about systems and how systems construct the need for secrecy and complicity so that everybody knew, and I still maintain that many, many, many people knew what had happened, and everybody kept a secret. And to me, I think, and I've really struggled, writing that piece was, I later said when it posted, I feel like I just wrote the first line of my obituary. Like that piece is gonna be the thing that people remember, and I never wanted to write that piece. But I think for me, what got lost in that piece was the part of the piece that said, all of my co-clerks knew, everybody at the Ninth Circuit knew, other judges knew, and there was something about this profession and the rewards and the power relationships that preclude coming forward. And to me, I wish that in some sense had been the salient component of that, because I think that those systems that reward sort of even low level, sort of just buzzing predation that goes on for decades, and the ways in which it is just too easy to say, alternatively, oh, the one bad apple is gone and so the system is fixed, or, I don't need to say anything because someone else said something. I think that we really won't have massive, massive change in our systems, particularly the sort of moribund, small c conservative systems, until we can figure out why there is such an enormous incentive to keep secrets, even after everybody knows. So that's totally unresponsive, and I'm sorry.
No,
but
I think that's very responsive to the question, and some of what I think a lot of us have been thinking about is how do we instill in our students who are lawyers some idea of when do you step forward And how do you balance, because I think you've mentioned that since then you've talked to people who've said, I still don't want to say anything about this because even though I'm 10 years into my career or 7 years into my career or whatever, I worry that this will somehow come back to haunt me. How do we instill in people the sense that part of what it means to be a professional is to step forward under circumstances like this?
So I feel like, Pam, I feel like you and I have talked about this offline, but I think one of the worries I have about MeToo, and I say this having talked to, Jodi Kantor and Megan Twohey at the Times, who did the Harvey Weinstein story, and, Irene Carmon, who did the Charlie Rose story, all of the journalists I know who are doing these pieces, I think have a similar anxiety, and the anxiety is that journalism is not a fact-finding process. It is not, at the end of the day, an adjudicative process. It is a process whereby, and there's good things about that and bad, just a whole lot of stuff gets smoked out that are secrets that people are keeping. And functionally, I think that's what MeToo has been. It has been journalism stepping into industries that regulate themselves with NDAs and with, a million sort of workarounds for the frequently men at the top, and then regulate the possibility of secrets coming out through these sort of contracts. And journalism comes in and says, okay, well, if she can't talk and she can't talk and she can't talk, journalism will fix it. And I think that we put a lot of weight on journalism to fix systems that are not fixing themselves. And I think one of the things that law students need to understand is that MeToo actually represents a failure of systems. It's a huge success of journalism, and there's nobody who's a more bullish advocate of a free press than I am. But if systems were regulating themselves correctly, MeToo wouldn't be happening. And I think one of the things when students come to me and they say, I want to tell you something that happened to me, which now is my life in the past year, my response is, I'm happy to write, I'm happy to do this, I will work with you. But also, what are we doing to fix the system that you operate in? Because if journalism is doing this, the next girl is on the hook too. And so I think part of, it's such a fraught question, Pam, but for me, part of the job is to both say to students, you have a responsibility to be, fixing this, not just by coming forward, but by helping us understand systemically why these things are still happening. And that's a lot to ask of a law student, but that's a little bit my present inclination, is that I find that when I say journalism is not an adjudicative process, people get very mad, because it's the only process out there for a lot of them. But that's a failure of other systems.
This is Stanford Legal, and today we're talking with Dahlia Lithwick from Slate magazine about the Supreme Court, complicity, MeToo, and just about everything else. Joe?
Dahlia, what would I take the point that you should work within the system first. Journalism is kind of a last resort. It's kind of a blunderbuss. It's going to smoke things out, but it's not going to do it in a nuanced fashion necessarily, and you can't control things once they get out. Let's go back to a situation where you see these boundary crossings. What can you imagine? And this doesn't have to be fixated on MeToo harassment. I view this as a general ethical quandary, because you could be a corporate lawyer. Pam and I interviewed the author of Bad Blood about the Theranos debacle. And that has nothing to do with sexual harassment, but it had a lot of people wondering, what's the right thing for me to do and when? So what might someone have done in, say, with Kaczynski, within the system that would have been better earlier?
Yeah, I mean, it's a great question, and I was one of the people, I think I said this in my piece, who reported contemporaneously at the time, and I think Heidi Bond, for instance, who was the first person who came on the record to talk about him, literally made herself crazy trying to talk to, the Second Circuit about, is there some way I can be absolved of my confidentiality agreement? That was her concern, that she was violating a confidentiality agreement she had signed in chambers, and that was her concern. So I think one of the things that needs to happen, and it's really hard, is for the system to say, and when I say the system, I realize that's just a completely fatuous shorthand, but for these systems to say, what are we doing that is precluding people from coming forward? And if it's the confidentiality clause, and to this degree, I think, John Roberts has taken, post Alex Kaczynski, has taken it quite seriously that reforms need to happen, and in, the entire Article 3 system, and I think has been, and Judge McEwen here at the Ninth has done serious work on this. But I think, one of the things that has to happen is understanding how these power situations come to be so asymmetrical that somebody will endure anything or will witness anything and not report. And I think that requires asking questions like, what is the scope of our confidentiality? I mean, now the new clerk handbook says you absolutely don't have a duty of confidentiality if this is about harassment or abuse, but that was not made clear until 2018. So I think some of these things really are going to require a deep look at, and I think, there's a way in which, again, I think each of us who's done a MeToo story has done it in the silo of our profession. So for me, all I've looked at is the judiciary and big law. And then you talk to folks in Hollywood or, in the media who are having their own MeToos, and everybody thinks their own is particularly noxious and crazy. But I do think one of the things that's just fascinating about the federal judiciary is the degree to which judges are just adorably checked out about everything. And they really somehow believe that everyone in the world is issued 3 sock-footed minions who will do everything for them, and that's just life. And, so then they'll say things like, well, am I allowed to ask my clerks, to get me coffee, as though that's a Me Too problem. That's a very different problem, and we should talk about that. But I think one of the things I've just noticed is the ways in which, for a federal judge to say, no, we're a family. We're a family and everything is okay because we're a family. And you want to just be like, dear God, we're a family is the problem because families are crazy. And, that's not the solution. So I think that there's a way in which we just have to really debunk some of the stories we tell ourselves in the law about how law firms work, about how power works, about how law school and access and power works. And I think I hate that. I mean, there's nobody who hates talking about the pernicious nature of the clerkship insanity more than me, because I benefited from it. But it's kind of nuts.
And when you talk about family, Dahlia, and privileged family, that kind of leads us into one of the big topics that people are wondering about. How about the most exalted family up there, which is a family of 9? And we've got some new members there. And,
so I'm told, yeah.
Yeah, we've got two new brothers, and we've got an uncle who took a powder. Yeah. This is Stanford Legal, and today we're talking with Dahlia Lithwick, senior correspondent for Slate magazine, about her columns and about the courts. I want to turn us now to that court and ask you a couple of questions about where we are now. And I guess the starting point is to kind of ask, Justice White was famous for saying that every time a new member of the court joined the court, it was a different court. How different do you think the court is going forward from where it was, say, before the momentous year of 2018 happened?
I mean, it's different in every single way. And at the micro level, right, you have 1 of 9 new justices who has come on, and everything is different for the reasons that Justice White would intimate. The entire institution is constructed around these 9 people having relationships, and that has changed. And then I think when you pan out, this is the first court in my lifetime without a swing voter. There will be 0 swing voter on the Supreme Court. That's completely new. John Roberts is, functionally at the center of the court. And if you look at his record, I don't think he's sort of in play on the issues that Anthony Kennedy was in play about. And what that means is, and this is really hard for us to understand, because for all of our lives, before it was Kennedy, it was O'Connor. There was always a person at the middle, and that's now gone. And I don't even think sort of psychologically we have figured out what that's going to look like. I think that the interesting question is going to be, whether this institution, which again we forget, we think it's so unbelievably powerful, but at the end, right, neither the purse nor the sword, it has no authority to do anything other than hope that the people keep the faith, and that's a terrifying posture. And so what is going to be new, I think, at the U.S. Supreme Court is John Roberts managing public confidence. And that's going to be his job. That's going to be the thing that when he wakes up in the morning and he's flossing, he's going to be thinking and trust me, I'm sure he's a good flosser, but he's going to be thinking, how do I keep this court from plummeting in public confidence? How do I keep it off page A1 of the newspaper for the foreseeable future? We haven't, not since we had the 4-4 court after Justice Scalia died, seen a court that is this anxious about its own public perception, and that's interesting.
I think for this show, we've kind of introduced really the topic for what's going to be our following show on Stanford Legal, whereas what does it mean not to have a swing voter, and what does it mean to be anxious about the future? And I'm going to also be wondering about how each of you is seeing this court after what for some people are really the trauma of the Kavanaugh hearings.
So thank you for joining us on Stanford Legal here on Sirius XM Insight 121. Welcome to our live studio audience here at Stanford University, and welcome to our listeners at home. This is Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman. Hi, Joe.
Hi, Pam.
So we're going to have a second show with Dahlia Lithwick, who is the senior legal correspondent for Slate magazine, a national magazine award winner for her columns there, author of a forthcoming book, Lady Justice, which you can probably at some point after the new year begin to order on Amazon, God willing. And also, and most important for our purposes, since this is our live audience show, an alumna of Stanford University Law School. So welcome back to the show, Dahlia.
Thank you for having me back.
It's good to have you back.
Dahlia, I want to pick up on something you said in our preceding show, which is that this is a different court. I know a lot of people are thinking, well, maybe Roberts will kind of assume the mantle of Justice Kennedy, and they're thinking of some decisions where he seemed to be swing voter-like, maybe like the Obamacare decisions. But it strikes me that those are really different cases. In Obamacare, we had a quite radical challenge to what seemed like a kind of bigger but kind of run-of-the-mill congressional executive program. And it's true that Roberts rejected that challenge. But that challenge kind of came out of nowhere a little bit, that a government program was going to run afoul of the Commerce Clause, for example, and had to be rescued on some obscure tax grounds. But these challenges are going to be much different. Roe v. Wade has always been challenged. That's not going to surprise anybody if he sides with the majority to get rid of that. Is this going to be, are we in for some radical moves in the early days, do you think?
I think that there are two moves that Chief Justice John Roberts has deployed when he's worried about the integrity of the court. One is the one you've described, and it's rare. It's the two, Obamacare challenges. There's been a handful of cases, actually notably in the last couple of terms, where he seems to have kind of migrated toward the center of the court and voted with the liberal wing. So that's one move where he changes his vote. There's another move that, again, you'll remember from the year and a half when the court had only 8 members, and that is you can hive off a little chunk of the case and decide something very small, or you can kick something back, or you can decide a sort of Bush v. Gore style one ride only. In other words, I think there's 2 moves, and it's important to bifurcate a little bit. One is to affirmatively vote with the liberals and say, X loses. I don't think we're going to see a ton of that for exactly the reason you've just described. But the 2 Obamacare cases were really Hail Marys. And if you look at his opinion in the second one, he was very clear that he said, don't ask me to carry water for your fanciful, right? I mean, he just didn't like the posture. He didn't like the way it was brought. And I think it offended his sense of, honor and sobriety. So those are the cases where he'll defect. But on the merits, if you look at his record on abortion, his record on affirmative action, his record on, voting, he's not somebody who's been swinging wildly. And so then the question is that second subset of cases. Is there going to be a way for him to not necessarily, quote, vote with the liberals, but to find ways to cabin the issue, to save for another day, to do sort of what in Numudno happens later in Shelby County? And I think that we will see.
Do you think the 4 justices who are to his right will go along with that, or are they going to try and force his hand by granting certiorari on cases that he would rather not have the court hear, on the theory that he will vote on the bottom line in favor of their position?
I mean, to the degree we have any insight about that, it might be the Wilbur Ross, right? The decision just recently.
You might want to explain.
Yeah,
the
court. This was a massive case involving whether the citizenship question was going to come back onto the census. And it was unbelievably consequential, part of the lower court opinion and then the Second Circuit opinion that Commerce Secretary Wilbur Ross testified that the reason this question was coming onto the census was because the Justice Department had asked him to do it, and then later evidence surfaced, emails surfaced, showing that that was materially misrepresenting what had happened, that he had asked the Justice Department to essentially seek to have this on the census. It seems like a nothing issue, but the consequence of this initial challenge was that Wilbur Ross himself was going to be deposed in this case to determine whether he'd been telling the truth or whether the sort of claims about the DOJ were pretextual. And the amazing decision this week was not, on the facts, just Wilbur Ross will now not be deposed, but Justice Gorsuch, writing for himself and Clarence Thomas only, basically said, we're going to get way out over our skis here and say that this whole case, I mean, that they're not going to win on the merits regardless. And that was an extraordinary, I think, telegraphing of exactly the answer to your question, Pam, which is you have people who want to get stuff done, and they have the votes to do it. And I'm not sure that they're as worried about the issues you're describing, the sort of public impression and integrity of the judiciary, as they are about getting stuff done. And if the question is which John Roberts, faced with that dilemma, shows up, is it the Rehnquist style, at the end of the day I'm an institutionalist and I will protect the integrity and prerogatives of this court, or is it the Shelby County John Roberts who's like, touchdown dance, we got it again? I don't know yet the answer to that question. I would say the only thing I think is very interesting in the last couple of years, John Roberts and Anthony Kennedy, with the exception of last June, but we're migrating toward the center on a lot of these questions.
One of the things that I thought was most interesting is last year at the Supreme Court of the 2017 term, if you look at the liberal conservative decisions, Justice Kennedy voted with the conservatives in every one of the 14 5-4 decisions that were liberals versus conservatives. He voted with the conservatives every time. The one real victory that the liberals had was one where Chief Justice Roberts joined the liberals, and that was on whether the government can get cell phone site location information, the stuff that your phones, if you hadn't turned them off already, which you all have, but if you hadn't turned them off, would be telling the government, would be telling your cell phone company every 30 seconds where you are, and the government could use that. And the thing I thought was most interesting about that decision, and the Chief Justice wrote the majority opinion for the court, is that it was strikingly not an originalist interpretation. That is, to the extent that people think that conservatives all want to look at the original public meaning or the original intent of the Constitution, he was not going there at all. Instead, what he did is he said, look, everybody today carries a cell phone. Carrying a cell phone is necessary for you to live in modern times, which was a surprise to me since I'm alive and I don't carry one all the time. But be that as it may, as my mother would say under these circumstances, you know, it was a modernist opinion. And so I wonder whether you think there are going to be some fissures and divisions among the conservatives in just how they approach fundamental constitutional issues, between the ones who say, read the text, the ones who say, ask what it meant in 1789, and the ones who say, let's look at it in modern terms. And before you answer that question, I'll just say, this is Stanford Legal, and today we're talking with Dahlia Lithwick about the Supreme Court after Justice Kennedy.
I think that we're going to see, and there's been some really interesting writing about originalism just in the last few weeks. Professor Eric Siegel's been writing about it. Rick Hasson did a deep dive on Eric Siegel's work. I mean, I think now there's going to be this big uptick in, are we really, you know, going to be as devoted to originalism, you know, the way we were to like not having a deficit, say? I mean, or is this just a convenient, was that mean?
No, that was okay.
You tell me when I get mean.
I tell you when you get mean. That seems like kind of risky.
Joe's here for that.
Bring it on. You can see how the audience reacted.
He is a licensed clinical psychologist.
Oh
he can tell when we're being too mean.
Can we just stop and talk about that then? So I just think that your question is exactly on point. And I think that there is a huge now burbling conversation about originalism. Was it kind of a pretext, and is it going to get abandoned? You know, Clarence Thomas is going to hold on to originalism forever, but we've seen in all sorts of ways, you know, Alito defect, Roberts defect for all the reasons, not just technology, but reasons of, oh, we didn't mean that kind of originalism, we mean this kind of. And I think that will be very much on the menu now, you know, trying to parse what kind of whether we're really going to hew to the sort of Scalia vision of original public meaning or whatever, or if, you know, now it's all bets are off because we have the five. I guess, you know, in a deep way, I think one of the lessons that I've learned, and it was probably most salient around the Brett Kavanaugh hearings, was that just a lot of things that we thought were rules or were immutable are just norms. And I just wonder if, you know, this story we tell about originalism was just kind of a thing that we did because, you know, it was fun and interesting. But now I think we're out of the world of, you know, that norms matter. And it'll be, I think, again, the question we forget at the center of all this is that I absolutely guarantee that the one speech every justice gives is, we're not political. This is not a political body. We are all not junior varsity, you know, politicians, the way Justice Breyer puts it. And John Roberts was at pains, you know, just recently to make that speech again, that if you think this is a 5-4 conservative liberal body, you are misapprehending all the 8-1 cases that we decide. That message gets diluted every time we have a Brett Kavanaugh hearing. I mean, it's really, you know, I don't know if folks know that Newt Gingrich just blurted out accidentally like a Kinsleyan gaffe, where asked whether, you know, if the Democrats take the House, and asked whether what's going to happen if the Democrats take the House, and Newt Gingrich accidentally blurted out at Washington Post Live interview that, well, I guess we'll find out if all that fighting we did over Brett Kavanaugh will pay off. And then he did one of those, did I just say that out loud? Thought bubbles. But, I think that that's really, the question is that every time the court takes a body blow, each of the 9 justices has to make a decision. And, you're going to see it. I don't even know what question I'm answering now. I'm just filibustering. But I think you're going to see it.
Well, the filibuster has been eliminated
Exactly.
for judicial nominations. So
now, I guess I would just say this. I think that you are going to see that anxiety play out. We've talked about John Roberts. You're going to see the conservatives. Am I going to talk in the language of originalism, or can I just say it doesn't matter, we won? And I think the liberals, you're going to see it as they try to do. Justice Sotomayor last week said, we're all getting past this. This Kavanaugh thing is not going to haunt us. And I think they are absolutely united at this moment in the desire to be not seen as a political branch.
I want to pick up on something you just said, Dahlia, which is the post-Kavanaugh world. And what I'd like to do is ask each of you, starting with Pam, how you're going to deal with it. Because Pam, you write a lot about the Supreme Court. It's pretty clear where you come down on various hot button issues, the political process, for example, voting rights and the like. But you also argue for the court. So now we have a new court. It's not a swing court anymore. Justice Kavanaugh is on it. What's it going to be like for you to argue?
Well, when you argue a case, you have to take as a given that the justices will listen to the arguments and decide the case on the merits. And at least up until this point, I've always found that the justices have been big boys and girls about this stuff. So I have academic writing that criticizes the court in areas that are my academic specialty. And I've never felt going up there that any of the justices would hold against my clients in a case where otherwise they would have ruled for that person because they don't like me. I think and I think several of the justices that I disagree with quite a lot, I get along with perfectly fine. What I think is true is that they generally have not held grudges against individual lawyers over those lawyers' positions. What they have reacted to, I think, with some lawyers is when lawyers are not candid with them, when lawyers in their briefs say things that turn out not to be true and the like. And so as long as you do a good job in your cases, at least up to this point, I have not been worried that I will not get a vote from a justice who would otherwise have voted for me. The first case that I argued on behalf of our clinic at the Supreme Court, we won 9-0, and Justice Thomas wrote the opinion for us. And this was 2 or 3 years after I had him in a class of mine down at the University of Virginia, where I was visiting that year. And he and I got into a huge back and forth about whether one person, one vote was actually constitutionally compelled or not. So, and as we were walking out of the room afterwards, I joked him and I said, you did say in one of your concurrences that you would have to reinterpret the Voting Rights Act because otherwise crazy things would happen, and you cited one of my articles and a proposal in my article. And he said, but I cited it with respect. And so, it's clear that there are some justices I will never get on certain kinds of cases that we argue. But I haven't worried up until this point about a justice just saying, I'm voting against your client in order to have payback for something in criticism you've made or the like.
And Dahlia, how about you? Because I know a lot of people are concerned that however you look at it, there's going to be payback from Justice Kavanaugh, for example, and you're covering the court. How do you either see the payback fears, or how does it sit with you covering this court?
So I think a couple things. One is, there's a funny paradox, and I noticed it years ago when I was covering John Roberts' confirmation hearings, which is Supreme Court reporters think of themselves, it goes back to the other show when I talked about baby con law professors. I think we really think of ourselves as principally, our job is to report doctrine. And the joke I would always tell is, you'd go into the press room after an argument and, all the reporters would be buzzing and you'd be like, did you see, Justice Breyer was like giggling with Thomas the whole time and they weren't paying attention. And everyone's like, oh no, did you see what happened to the Dormant Commerce Clause today? Like that's where, what we do. We cover the law. And I used to always joke, we cover the court as though, the justices are dead and the Constitution is alive. And I always thought that was crazy. But it's interesting because one piece of fallout of that is that when you go to the hearings, there are very few Supreme Court reporters in the room. So, Nina's in the room and Jess Braven's in the room. But if you go back and you look at all the Kavanaugh reporting in the Post and in the Times, those are not Supreme Court reporters reporting those out. Those are political reporters. This is a political story. And one of the ways, and it goes maybe back, Joe, to your complicity question from, one of the ways we all get along in this big family that we call the Supreme Court and its press corps is that we bring in outsiders, right? To do the dirty work of, now we're going to call Squee and PJ and find out, what happened. Like, I'm not going to do that. So that's, I think, the trick. That's how we do this. And it's problematic for a lot of reasons that I think are implicit. If you were, and I was, in the Dirksen hearing room, when then Judge, now Justice Kavanaugh, was like slamming the binder and like banging things with the pen, that was really disturbing. It was like beyond just the like, this is all, dark money and the Clintons avenging themselves, which was really difficult to hear if you're a junior con law professor or even a con law professor like Pam. This is really hard to hear. And I think if you're in a room full of political reporters, you just say, this is how our government works now. But if you're in a room full of people like your law students or like law faculty who perhaps signed that letter, and like Justice Stevens, who took a position which has never been done before, and you have now taken a position and said, like, I'm not sure this person's temperament, based on that hearing, not his record, is fit to be in the room, then how you go into the room and play nice, I understand why the justices have to do it, but it is really difficult for some of the reasons, at least sort of you're eliding in your answer, but I can just say out loud, it's really difficult to be in the room and think, is every time an ACLU lawyer who stands up in that room and argues, is there one person who thinks that that lawyer is colluding to shame him? And the only other thing I would just say, and this worries me deeply, and Pam's written about this a lot, I've written about it less, but already the justices have a deeply antagonistic relationship with the Supreme Court press corps. And I don't mean like they hate us. I mean, by and large, if you look at the dicta in Citizens United, if you look at the dicta, in the ballot signatures case, the way they talk about the press is as this sort of malevolent, feral, group of people who's out to get them, who wants to like put their personal information online and shame them. And everything about that hearing dovetails with that idea of the press. And I will not be surprised if in the coming weeks we hear, again, I suspect it will be across the boards, justices saying the press isn't doing honorable work, they're doing gotcha journalism, they're trying to shame and embarrass us. And that's the part that scares me because, and Pam's written about this more eloquently than anyone, that then turns around and inflects on First Amendment doctrine. And so when you have the justices who feel as though Brett Kavanaugh was unfairly destroyed for all those MeToo reasons we talked about before by the press, if you think that is not going to start to leach into the way they talk about press freedom in the First Amendment, I think that's incorrect. I think we will now have a real block of justices. Before it was mostly Clarence Thomas and Sam Alito who talked about the press in these terms. I suspect we're going to hear more of that, and I think that it's going to start to affect our actual First Amendment, the contours of First Amendment rights.
This is Stanford Legal, and today we're talking with Dahlia Lithwick about the Supreme Court after Justice Kennedy. Joe?
So it sounds a little bit like what you're saying is we had this family, and it kind of, I don't know whether it worked or not, but it worked in the sense everybody was able to keep up this fiction, and the fiction served maybe a lot of laudable purposes. It made it a little bit easier to accept an argument on the margin that you might be skeptical. There's this kind of line about, let's see if I get it right, hypocrisy is the what vice, the homage vice pays to virtue. That is, it kind of helps a little bit. And now it's breaking down there like everywhere else.
Yeah, I mean, look, I think that there's no question that at bottom, these are 9 people who have to get along, and who get along by, you know, the way you get along at Thanksgiving. You ignore the crazy uncle, and, you know, you tell him you really like his tie, and then you, like, have another drink. Like, we have skills for this. And I think that that has driven a lot of, you know, the language of decorum and the language of civility is exactly what you're saying, that this is what we do in order to have functioning institutions. And I think you're right. That's falling apart, not just, you know, in every other branch of government. I can tell you, I interviewed for my podcast, I interviewed Senator Jeff Merkley last week, and I said, come on, tell the truth, you know. I know you're all yelling at each other, but then you get on the elevator in the Senate and you fling your arm around each other. This is all a joke. And he said, people aren't talking to each other in the Senate. He's like, people are no longer speaking. And so we have this problem, which is, and maybe this is this unifying theme of everything we've talked about, you know, the scales have fallen from our eyes, right? We're not going to play anymore. But institutions, in some ways, are reliant on those little lies and hypocrisies that we tell ourselves. And so it is really hard to think about a Supreme Court in which people aren't, you know, doing the cordial, civil, respectful thing. But it's also hard, given the road that we've just come down, to understand how you can.
Well, it's kind of a microcosm. I love your summary, both of the show and kind of where we are as a nation right now. So we want to thank you for being on Stanford Legal, and we'll look forward to having you back.
Thank you.
His explanation, obviously he prepared ahead of time to give an answer which was way off orthogonal to what the real definition was. That seems to me to be outright lying under perjury. Is anybody ever really upset about that now, or is that an issue that's gone long gone?
So the question is, if folks didn't hear, you know, that the Judge Kavanaugh's remarks about his yearbooks, like, just at that point strained credulity to the point that it seemed like it was both prepared and it was not truthful. And the question was, you know, is that still in the ether? I don't know, Pam, if you want to, I mean, I guess I would just say, you know, there were things around, you know, the Manny Miranda, the leaked documents, you know, in the Judiciary Committee. There were things around preparing judges. So there were a lot, different people found themselves saying, this is the thing that is just manifestly not true. And for some people, it was the yearbook. For some people, it was, you know, you cannot possibly say that those leaked documents that came to you and said, you know, these are leaked documents, that you thought there was some spirit of comity in the, you know, Judiciary Committee to share them. Different people had different feelings about it. I think what I would say is, you know, had there been a meaningful investigation of all of this, that was a really robust, bipartisan investigation, we wouldn't be so frustrated right now. And I think that, again, you know, it goes back to the, you know, journalism is not a fact-finding process. It really wasn't there. I mean, what journalism did was journalism put the yearbooks, you know, out. It would have been really useful to question all the other people who put that statement in their yearbooks and find out what it meant. We just didn't do it. And so I think that, you know, again, my answer as a lawyer, first and foremost, is like, imagine if there was a system to find the truths behind assertions. Oh, wait, we have one. But we chose again and again and again not to use it. And so, you know, in some sense, That's what I'm angry about. Not any one misrepresentation or distortion, but that we have the wherewithal to find out the truth behind things that seemed as though they were demonstrably untrue, and we didn't do it.
Dahlia, have you given any thought to the characteristics of the justices who have moved from conservative to more to the middle, or in many cases, some cases, to the far left, and whether Justice Roberts, who's the one you've identified as the possibility, shares any of those characteristics that gives you some hope that he might move?
It's a great question. Did folks hear the question? It's a great question. So first of all, I will not surprise you to hear that the people who study this are the political scientists and not the con law professors, because this makes them very nervous, right? This is now talking about the court in political terms. And the research is really interesting. The research tends to show that justices who drift across time overwhelmingly move from the right to the left, less so from the left to the right. It does happen. And often it's just a function of getting older and saying, I didn't know what I didn't know. But I think that largely the reason we don't see justices move, there are two reasons. One is that we select out of that, right? Because the rule is we will never have another suitor, and that is a programmatic, right? That was one of the reasons Harriet Miers doesn't get confirmed, is because who knows where she was going to move. And there was a real terror of that, of somebody like a Souter or a Stevens who didn't fulfill the promise. And so we now make sure when we select our nominees that we pick people who don't drift. But I think that the other answer is that we didn't used to pick people who were sort of like hatched in underground pods to be sort of the ideological actors they are, right? So this is the first court that we don't have anybody who's never run for office. We don't have anybody who's done, think of, Robert Jackson, think of Earl Warren, think of the backgrounds of people who either came to the court through politics or came to the court through academia or came to the court through some sort of intellectual baking process that allowed them to be in motion. And now we really do have, and I think more and more we have it on the left and the right, a system that abhors the idea that somebody will not be exactly what you want them to be, and we select for that. And by the way, we select people who are 35 years old. We're now having confirmation hearings this week for people who are closer to my kids' age than mine. And I think that if you select people who come up through very rigid, systemic screening processes, and they have one or two jobs, and they come from whatever their government work is, and then up through the federal bench, you're just not going to get people who say, the way you might have heard on the Warren Court, good point. Maybe I don't, I'm not as doctrinaire as I thought. So those are my sort of short answers. And if those are my answers, then I think John Roberts, who was selected unbelievably young, and also who was very much part of this sort of Federalist Society machinery that really is, by design, grooming people from law school to come on the court and do certain things, then I think you're just probably going to see a John Roberts. As I said, I think there will be ways in which he will surprise us. I suspect it's going to be more, we will do it small this year and we'll do it big in 5 years, rather than I'm, wholesale voting with the liberals. I don't think we're going to see a lot of that, but I do think that what we know of John Roberts to this point is that on the issues that, both O'Connor and Kennedy were in motion, he's really, really not in motion. There may be, and I think this is where the travel ban case was interesting, I thought that was a case in which maybe the John Roberts who cares about sort of civility and how we treat each other and how we talk might have been, affected by Donald Trump's language around the travel ban. But he wasn't, as it turns out, in play on that either. So,
well, he did say that we should finally agree that in the court of history, Korematsu was wrongly decided,
yeah.
which seems a little, $1 short and couple of decades late. If I could say just one very brief thing to your question, which is one of the huge differences, and this is a generational shift, Justice Kennedy's generation to the next generation, is the two political parties did not used to be as ideologically polarized one from another as they are now. That is, Harry Blackman or, John Paul Stevens or Anthony Kennedy or David Souter was representative of a large part of the Republican Party of their time, because the two parties were not divided the way they are now. You had very conservative Southern Democrats and moderately liberal Northern Republicans. And so when the two parties nominated people, it was entirely possible to have that kind of cross breeding. So the most conservative person on the Supreme Court during the years during most of the years in which the Supreme Court was deciding abortion cases was Byron White, who was a John F. Kennedy appointee. Today, you would not see that, because starting in about 2010, in Congress, the two parties are absolutely polarized. The most liberal voting record by any Republican in Congress is more conservative than the most conservative Democrat. And so that division among the parties means that when the parties nominate people for the Supreme Court, they're not going to have the kind of ideological overlap that leads to drift one way or the other.
And maybe just the coda to that, sorry, and then we'll take other questions, but I think the coda to that is, when you asked John Paul Stevens, why did you drift to the left over your career? His answer is, I didn't move at all. The court moved around me, and what was, the left wing of the court when he came on as a Republican, what is now gone, and what was the center of the court became the rabid, deranged left, right? And what was the right of the court became the center of the court, and now we have this other. So, I think he would say to you that I didn't drift in any direction. I think this is the court version of what Pam's talking about in Congress, which is that the court has moved. It's not that the justices have moved at all. Yeah.
I'd like to return to the MeToo theme. Thank you, by the way, for an excellent discussion. And I guess what I'd like, my classmate and now wife was on the Judiciary Committee staff at the time of the Clarence Thomas nomination in 1991. And what I was struck by watching this is how much, with the possible absence of the crazy John Doggett character, this was almost a verbatim replay of what we saw. So I'm wondering about what your assessment is on what the impact, we're all doing stock taking on what the impact of the Me Too movement has been with respect to Washington with judges. I'd be interested in your reflection on where we've come in 25 years and what it signals in terms of where we're going.
A couple of things. One of the things that was extraordinary, I rewatched Anita Hill before the Blasey Ford hearing. That was my homework. And it's an extraordinary, I made my son watch it, my 15-year-old, because it's an extraordinary sort of archival document of how a woman can't be angry, can't be emotional. She was really an extraordinary, that was like nothing I've ever seen, and it's still as salient today. I think that, and I have to believe this, the difference for me between 1991 and 2018 is that there was an all-male Judiciary Committee for Anita Hill. And I can't tell you what it meant to have Kamala Harris and Amy Klobuchar and Mazie Hirono and Dianne Feinstein in the room. It just became, instead of just being Me Too, there was Me Too, anger, and power, which is really different. That there were women in power, and not enough, and maybe not enough to make a difference, but to be able to see that as a marker was very powerful to me. And then I think in other ways we just move backward. I think there are ways in which, to not have the courtesy to question Professor Hill, to question Dr. Ford to her face, to kind of contract it out to someone, and then walk into the elevators and say she's a liar, it's a hoax, seemed so dishonest to me. And it was as though we can't do what we did then, so we're going to do something cheap. And that struck me as moving in really a wrong direction. So, I'm still, like you, trying to process what's different. I guess what's different this time is, we have a record number of women running for Congress. We have a record number of women running for governor's offices. We have a record number of women running for attorney general. And one of the reasons, I was saying to Pam, my book isn't just about women in anger, it's about women in anger in law, is because I think that law is a huge lever in this that we have access to that we didn't as much then. And that's, to the degree I can offer you a sort of a thing that I'm sanguine about, I think that having women in power is the difference. Maybe not enough.
Hi. In the time that you've covered the Supreme Court, how often do you think oral argument has actually made a difference in how a case has been decided as opposed to what's already been written?
Do you want to answer, Pam, or do you want?
Well, you should probably answer it because it was asked to you.
Yeah, no, I mean, in the times that, okay. I think that the official Supreme Court oral advocate guidebook says you can't win an oral argument, but you can lose one. You can lose a case by being bad in oral argument, and I think that I have seen. I have seen somebody get up and say something catastrophically erroneous, and then they lose. I don't think I've seen a lot of cases where somebody, at oral argument did something that hugely changed the needle. Pam's going to tell you about all the times that Jeff Fisher did it. But I think that the sort of academic answer is, it doesn't make a huge difference what oral argument, and you probably know this, oral argument is largely the way the justices talk to each other about the case and the way they try to suss out what people are anxious about. And so they're using the argument to sort of say, this is what Justice Kennedy is worried about. Okay, well then I'm going to, drill down on that. It's not, I think, a sort of a, him versus her as much as we think. I think it's a, where do I smell a little blood in the water as a justice, and how do I try to sort of cantilever this into something that could appeal to them? That's generally what I think happens at oral argument. Now, Pam's going to tell you I'm wrong.
No, I don't disagree with that. I think you can win a case in oral argument if a justice comes into the case thinking, I'm concerned about the following thing, I need to be reassured it's not going to happen. So that's the kind of case where I think you can win. That is where justice says, but if we decide this for you, isn't this terrible thing down the road going to happen? And you say to the justice, no, actually, you can decide the case for my client in a way that doesn't open up a box of horribles. I mean, one thing to keep in mind is most years, somewhere between 30 and 40% of the Supreme Court's cases are unanimous. And in those cases, lots of people think, well, those cases can't be won or lost in oral argument. That's not true, because you can have a 9-0 case where every justice is very close to the fence, and the oral argument can tip all 9 of them one way or the other. Conversely, there are 5-4 cases where nothing you do in that room, I mean, to kind of paraphrase Donald Trump, you could go into the room and right after you've shot a whole bunch of people on Fifth Avenue and it won't change the result, because going in, exactly that, you can't see where your fifth vote is coming from, or the other side can't. So I think an oral argument can make a difference there, and it can make a difference in how the court writes its opinion in your case. And so if you are representing kind of a repeat player at the court, you can try an oral argument to get them towards a result that will be better for the follow-on cases or worse for the follow-on cases. But the number of times that a justice comes into oral argument thinking, you're a loser, and comes out thinking, wow, that was so inspiring, I want to vote for your client. You could count those on the thumbs of one hand that you don't have.
I just wanted to ask about the way in which special interest groups seem to be directing the nomination and the appointment of judges. The Federalist Society seemed to have curated a list, and in the third iteration added Kavanaugh when it became apparent that there could be a criminal prosecution of the president. The U.S. Chamber of Commerce, for example, has a huge budget that seeks nomination of particular candidates. It strikes me as very odd to have these special interest groups who then draft amicus briefs which come before the court. I come from the UK tradition, and I just find it astonishing that you could still say that there's some sort of separation of power here, given this type of influence and expectation, I think what Joe referred to as a payback in these cases. I'd like your comments on that. Thank you.
I would say if you haven't read Senator Sheldon Whitehouse from Rhode Island, he's been doing this both through the Gorsuch hearings and through the Kavanaugh hearings. This is all of his questioning is about this, and it's about, who is paying for your commercials, Judge? Why are there multi-million-dollar dark money? Whose interest is at work here? And I think that he has really tried to draw the line between special interests, whatever they may be, the unions cases. I mean, there's just too many examples that you can blinker yourself to. I think, there's no question, and it does go back to, and by the way, in state Supreme Court elections, it's vastly worse, right? In states that elect their justices where millions of dollars of dark money comes in and their ads, and it's unbelievable that that's how we pick our judges in the states that do it. And I think that it goes to this sort of, as long as we keep believing that the day you're sworn in and you put on your robe, something magic happens and you stop being partisan, this works. But it's really hard for people to believe that when there are multi-million-dollar campaigns to get somebody a seat on a U.S. Supreme Court. And so I think that in the end, what you're describing is this sort of aggregated cynicism, and it is not, you're not the only one who's finding it sort of astonishing. I think that it is very interesting to see Senator Whitehouse devote all of his time to this at hearing after hearing, and nobody reports on it and nobody cares. So there's a way in which it's so thinky and so sort of abstract, and the sort of attacks on the other stuff are so concrete and reportable, that the story you're telling, which I agree with you, is an unbelievable story about influence and buying influence, gets sort of short shrift in the national narrative. So you should read him, and then you should send him a letter and say, thank you for your work on this, because he really is, I think, single-handedly trying to make this point, and nobody seems to register.
And Dahlia, do you think it's different from, for example, the women's groups that lobbied on behalf of Justice Ginsburg, or the NAACP for Marshall? I mean, is there a distinction because there's dark money versus overt, or how do you see that?
I mean, I think that's the difference to me, is the money. I think that there's no question that all the women's groups came out in favor of Sotomayor and Kagan, and they came out in favor of Ginsburg, and that we live in a country where there are parties who have interests in litigation who also are sort of lobbying. But I think that and by the way, this is now happening on the left. We have groups on the left that have money, and we don't know who the donors are, who are paying unbelievable amounts of money to defeat nominations. So I think, the real problem is, for your purposes of this question, is that some of the groups on the right are better at it, and there's more money. But I think for me, that's the difference, is the lack of transparency. And if people are spending millions and millions of dollars to seat a justice who will then, make decisions about their cases, I would like to know who they are. And it's the not knowing, I think, that for me is the problem.
So we have time for one last question.
So it's fitting that this is the last question, because I'm going to ask you, Dahlia, about the most recent thing you wrote.
Okay.
So this was for Slate, and this was, for those who haven't read it, a political scientist explains why Democrats must pack the courts to restore democracy. Now, it's not a column, it's an interview. You interviewed Aaron Belkin, who's the chief proponent of this, and I'm not going to be so cruel, because I'm from Minnesota now, and I'm nice, so I'm not going to make you go on the record and say you agree or disagree. But
dude, I'm Canadian.
Yeah, right. You're nice par excellence,
in a
right?
nice
Exactly.
every time.
I know, but we're both Jewish, so there's a tinge there. So But if you thought this was completely like off the table, I assume you wouldn't have bothered to interview him and publish it in Slate. So do you think it's healthy, at least for schools such as Stanford, for faculty, for others who care about the court, to at least have this debate so that this idea, which has maybe been off the table since a switch in time, save 9, is on the table? Or could this be really dangerous and damaging, not just for the Democrats' prospects of taking the Senate in 2020, but just for our democracy, if these ideas gain some currency?
Yeah, I mean, I interviewed a poli-sci professor who did a whole bunch of the work around Don't Ask, Don't Tell, and the trans ban, and I interviewed him this week about this new initiative he's putting together that includes putting 4 more justices on the court if the Democrats take the Senate. And I did do it as an interview, in part because this was a third rail to me. I've always said I think that court packing is mutually assured destruction, and I don't want to live in a world where we have 700 Supreme Court justices, because every time somebody takes the Senate, they put more.
But think of the number of Supreme Court clerkships that would.
Right. No, I mean it would certainly solve the clerkship pipeline. There you go. Pam fixed it. Fixed it for you.
I try to look on the bright side of everything.
Fixed it. So I think part of the reason I was willing to give him a platform is because and this a little bit goes back to I think the political scientists are much more clear-eyed about what's going on right now than the folks who, continue to insist that the court is magic. And so one of the reasons I wanted to talk to him, and I actually I asked him only hard questions, I thought, and I thought all of his answers were actually more persuasive than I thought they would be. And that was my interest in doing that, was to say, I'm not all in yet on court packing. I am very interested in people saying, if there are no rules, then we should figure out what that looks like. And I have to say, I mean, I went into that much more of the view that, the one thing that FDR did as a popular president that almost tanked the presidency was this. So the idea that, we're setting this up now strikes me as a horrific idea. But I think that it was, for me, much more heartening than talking to all the people who are just like sobbing, which is not interesting journalism. So I think that's my answer.
Well, thank you all so much for coming, and thank you all for coming back to Stanford. It is so great to see you. So hope you have a great weekend.